Our host, Sid, as usual, your weekend warrior. This morning, we have a fabulous guest whose expertise I think we could all use, actually. Before we get into today's chat, however, let me introduce you first to attorney Jonathan LaCour, founder of Employees First Labor Law of Los Angeles, which is a firm that caters to those who are wrongfully terminated, discriminated against, harassed, or injured at their workplace. Now, thank you for joining me today, Jonathan. Thank you.
Thanks for having me.
Of course. This is something that's actually quite close to my heart for many reasons, and you guys will see why. For some context, Erupters, what we are here to dissect and discuss is essentially how to sue your employer for workplace abuse and win. But specifically from the point of view of the recent news out of Elon Musk's very front-facing, very popular, always in the news company, Tesla, Inc. Owen Diaz worked at Tesla as an elevator operator, as a contractor at a factory in Fremont, in California, for only about a year, from 2015 to 2016. Owen is Black and of Mexican descent as well, and in that year, experienced such heavy amounts of racial discrimination and abuse that he then embarked on a 4-year journey to get to be able to hold the car maker to account, essentially. He described working conditions as hostile and reminiscent of the Jim Crow era South, specifically, having coworkers draw swastikas in the bathroom, use racial slurs on the factory floor, and more. And though he bore the brunt of this abuse, Mr. Diaz's son, Dimitri, who was also employed there, began to have a similar experience, which prompted Mr. Diaz to file a complaint, and then another complaint to supervisors who, essentially these complaints fell on deaf ears. And he left, right? So in total then, 3 former employees, Mr. Diaz, his son, and another, essentially sued the company, though only Mr. Diaz's case successfully took the electric automaker to court. And the San Francisco jury's verdict ruled that Tesla should pay $130 million in punitive damages and $6.9 million in emotional damages to Mr. Diaz. And according to Larry Organ, who is his attorney, he is now the recipient of the largest award in a racial harassment case involving a single plaintiff in U.S. history. Now, thank you for bearing with me through all of that, because I know you know all the ins and outs, Jonathan. But first off, any thoughts?
Yeah, there's a lot of thoughts here. I know the attorney that secured that award.
Oh wow, okay.
Art Alexander. He's a friend of ours, a friend of the firm, and really what his case stands for is that society as a whole is rebuking the idea that the brown and Black communities should be basically subjected to this type of harassment, this type of hostile work environment on the basis of race. Because in today's communities, in this day and age in 2021, we should be beyond somebody's skin color. We should be beyond somebody's race, national origin, ethnicity. We should be beyond that. It shouldn't be a factor. But as that case kind of illuminated, it really is real. It's still in the community. It's everywhere we look. It's hiding. And, it really is there. In that particular case, a lot of people talk about the gigantic award. It's $137 million or so. And how would you get that amount? And I have some thoughts on that. The emotional distress damages component of it was about $6.7 million. I'm not sure if you're aware of that, Sydney. But the punitive damages award was $130 million.
$130 million, I know.
It's $130 million. The jury essentially said...
Talk me through punitive damages. Because if in layman's terms, what does that mean?
So important, right? Because to get punitive damages, you essentially need to show that it was rung up the flagpole. It was a director, officer, managing agent that made the decision that caused this harm. It's not at the low levels. And a lot of people, I've talked with family, I've talked with friends. A lot of people say, how can you get that amount of money if it was just a low-level employee? It really wasn't the company.
Right, especially because the company said that they fired 2 other contractors who were accused of it and also suspended another. So in fact, they felt like they took action, but...
In the trial, you need to show it was a director, officer, managing agent of the organization that acted with fraud, malice, or oppression. Okay? So it's not an easy burden. It is not an easy burden. It is a hard burden. And in that trial, essentially what Bernard had to prove is that it was run up the flagpole, and whoever handled it did so with malice, oppression, or fraud. It was so bad, it had to have been so bad, that they awarded $130 million. Now, will all 130 be collectible? That's a different story.
Okay, so before we get into that, I want to backtrack a bit because I want to talk about this process, because 4 years have gone by. This took Mr. Diaz 4 years. He spoke to, I forget exactly the press outlet, but he spoke to somebody in 2018 about this. And now, of course, it's all over. We're seeing it on NPR, we're seeing it on the New York Times, we're seeing it on ABC, on Time, in Time magazine. Like, we're seeing it everywhere. But again, 4 years of work for this verdict. So let's talk about that process. Talk to me about how one goes about bringing a corporate giant to task in this way.
So 4 years is not uncommon, unfortunately.
Okay. Start with, for me, I want you to like track it from like complaint to literal verdict. How do we get there?
So part of the strategy of defense attorneys, and I'm just going to be completely candid, is to prevent, delay, obstruct, prevent, delay, obstruct, continuance, obstruct, so that your plaintiff gets tired. And part of it is they're hoping that they're so, tired of the case that towards the end, the plaintiff will literally just give up. I've seen it before. So part of the strategy is, how long can we possibly stretch this out before trial? You have a rule essentially that says if you initiate the case, you need to try it within 5 years. If you go beyond the 5-year mark, your case is going to be dismissed.
Oh, okay. Wow. And then you're also like up to your butt in legal fees.
In legal fees, in costs, okay, in expert costs. And so defendants, what they'll try to do is try to delay it as much as possible, make it as expensive as possible. Then when they lose, assuming that they do lose, appeal it for several more years. This case is not over. They're not going to open up their checkbook and pay him.
And write it. Okay, so that's the other part of this. But like, what constitutes abuse? Because your firm talks about.
You mean a hostile work environment or abuse in litigation?
Oh, no. Well, abuse in litigation, I feel like we could have a whole nother segment.
Yeah, we could.
I mean, in terms of a work environment, because like your firm focuses on wrongful termination, discrimination, harassment, injury, but like what constitutes harassment or discrimination that you, enough as a lawyer, understanding all of these things about the defense, understanding what it's like to bring a corporation to essentially like hold a corporation responsible for this, like knowing the process, I'm sure you're discerning about what you go about taking on as an attorney.
Yeah,
like,
of course.
What constitutes abuse that an attorney will go, you know what? You have a case.
In these types of cases, there are really a couple of major claims that we need to be aware of. Okay. Right? It's a hostile work environment on the basis of a protected class: race, gender, religion, sexual orientation, disability status, something inherent to you as an individual that makes you who you are, that you can't change. Okay? And then reporting that conduct, giving the company an opportunity to remedy it, because there's no gotcha lawsuits. You can't do that. So you give them an opportunity to remedy it. But then if the company, still knowing what happened, doesn't fix it, then there's a failure to prevent discrimination, failure to prevent harassment type of claim. This case is super important because you don't see this type of verdict, you don't see these types of results where there's no wrongful termination.
Especially not with a Black plaintiff.
Well, we're going to start to see a lot more of, race discrim coming out, big verdicts, okay? Because the community is now rebuking that, okay? Right. But, in the past, what you had to have happen is an adverse employment action. You make the complaint, and then suddenly they fire you for some legitimate, non-discriminatory reason.
Right.
That you prove is pretext because, I fired because I complained that my manager called me the N-word, right? That's traditionally how this happened, but this didn't even have a wrongful termination claim. They said the harassment was so bad, they were able to prosecute that on the emotional distress component alone.
That's crazy.
Without the wrongful termination. And that's why this case is special, because now you're going to see, I think, people in the community no longer requiring that there is a wrongful termination component, so long as the harassment that's based on a protected class is so bad. And we're going to see a lot of cases where people wouldn't pick them up, start to pick them up because the harassment, the hostile work environment, you know, your boss making your life a living hell, giving you too much work, not enough work, telling you you're stupid. All of those things are going to start to become actionable if it's based on your race or gender or religion. It's going to be something that's happening, I think, a little bit more. The cases that people wouldn't look at are going to be looked at now.
I also think that this is a precedent for so many different reasons, right? I think there's a lot of people who endure a level of workplace abuse or hostile environments at work and go, you know what? It's not so bad. I'm not being, it's not so bad. I'm not, if you're a woman, it's like, well, I'm not being assaulted. I'm just being somebody's just making like lewd comments to me every day. And
that's still severe and pervasive. It can be,
exactly. And I think we gaslight ourselves because we're so used to A, there being no repercussions, or B, the repercussions falling on you for standing up for yourself. So I think that this lovely man, I don't know if you saw his interview on ABC. He's just like so kind and also so determined. Like it is going to be so inspiring. I agree with you, for so many members of Black and brown communities, especially in working class situations, who aren't necessarily involved in corporate America in the same way, who are like, you know what? I actually don't deserve this. Right. I don't deserve this. And I get to stand up for myself. Okay. So my next question is, how do you make a case stick? How do you make a case stick in this way? Because Tesla has been dogged by allegations of racism at auto plants for years. Right. And most cases don't ever make it to trial because employees are bound by arbitration.
Oh, yeah, so this is super important.
Let's talk about arbitration, because I think for those, I've done my research in order to talk to you today, but I also was like, huh? Yeah. So, yeah, talk to me about that.
Arbitration, and I'm just going to be completely candid because the people that are watching this
we want the truth.
They need to know. They've got to know. Arbitration is probably the worst thing that can happen to you when you sign an employment application.
Okay. It just is.
Because employers use arbitration as a way to essentially be allowed to do illegal things to you and get away with it. Let's talk about arbitration. What is arbitration? Arbitration is a private trial. There is a private judge. The judge is paid for by the defendants and the insurance company. Okay? And it's not a little amount of money. It's not a little amount of money. I have arbitrators that are being paid $17,000 per day.
Oh my God.
Per day. They'll make $200,000, $300,000, $400,000 in an arbitration.
You know what? I quit. I'm actually going to go to law school.
Me too. Okay. So, what's that old adage? You don't bite the hand that feeds you, right? So you're going up against an arbitrator that's being paid an enormous sum of money. And it's kind of known within the community that, hey, if you're bound by arbitration, you're going to be stuck with a judge that's going to have a financial incentive to find in favor of the defendant. Now, does that always happen? Not always. But it is super suspicious, and it is very problematic. I had a judge, an arbitrator, rule against me the other day for in forma pauperis. Okay? That's a legal concept that basically people without money should get a waiver of costs. The arbitrator ruled against me that my client couldn't be in forma pauperis for the cost of the arbitration, for the cost of the court reporter for the hearing or depositions. In state court, it's literally a form that you fill out. The fact that I had to file a motion for that speaks volumes. It can be very unfair. That's why Me Too happened. Because all of these women with...
Okay, and Cosby, same thing. It's like you have all of these like secret, private, pre-trial moments in which... Or, somebody makes a promise. I mean, that's how Cosby happened, right? Like you make a promise that you're going to keep certain things in arbitration that don't end up staying there, or that end up being fodder for the bigger trial later. But what I do find insane is that, again, like if I were an employee and I were being abused and I knew all of these things, like I would never speak up. So my question to you also here is, Do you think labor laws adequately protect workers from this kind of abuse, from hostile environment?
Well, let me go back make one point.
Yes, okay? Absolutely.
It was so bad, arbitration has become so bad that Gavin Newsom made it illegal as of January 1st, 2020 to condition employment on, condition somebody signing an arbitration agreement on employment. Okay, it was sued by a group to enjoin, to prevent that from happening.
Right.
And it literally just got undone. And now, again, it is illegal for an employer to condition entering into an arbitration agreement for employment. So all of your watchers, listeners, if you have an employment agreement, you have an arbitration agreement, revoke your agreement to arbitrate claims. Because if you get injured, get pregnant, you need time off, they would potentially be able to fire you and not face the repercussions that you would if there was a jury involved. A jury of 12 of your peers that would be able to say that was wrong. Okay? So if you have an arbitration agreement, undo it. Say that you no longer agree to arbitration. But I'm sorry, that was the last point. I needed to make that because it's super important that people know how to get at it.
No, that's huge. That's exactly right. That's exactly why I asked the second part of it, because when you say that, it immediately makes you go, oh my God, the state is not on my side. Oh my God, they do not have my best interests at heart as a worker experiencing abuse. And I do think that, that's amazing. That's actually, are we one of the only states that does that? Or is that like a nationwide experience?
We are. What do you mean? Do arbitration or
no? Events? That have rejected arbitration.
So yeah, we are. As far as I'm aware, we're the only state that has said you cannot condition somebody entering into an arbitration agreement on employment. And what they'll do is the employers, they're sneaky because they realize people sometimes don't want to sign them. They'll give you a big onboarding packet. It's this thick. You'll be signing papers, doing your W-9, doing your W-4, and it'll be hidden within there, and they'll say you need to sign all documents to start work. I see that all the time.
Oh my God.
It's gotten so bad that I had an employer fraudulently create a document that essentially said my client signed arbitration, but they put the wrong year that he was employed.
Oh my God.
It's that bad. If an employer is going to that length to get you to be in arbitration, it's not fair, right?
No. Huge red flag, right? Okay, well, let's talk about breakdown of damages. Who decides what the breakdown of damages is? And do we think, because this is such a huge case, right? This is such a huge award. What do you think the appeals process is going to be? Do you think the Diaz's are ever going to see that money?
Yeah, I think they're going to see a massive amount of money.
Okay.
So let me put that in the universe first. Okay. But, yeah, so the breakdown is damages that are going to be your non-economic compensatory damages. That's your emotional distress, your humiliation, your loss of self-worth, your, depression, anxiety, those types of damages.
You can literally put a monetary value on your worth in court. I'm dead.
They do. They do. And, you'll go to the doctor or you'll talk about the change of, this person's personality and, how it's impacted and prevented them from living their normal life. And they'll put an award on it. In this case, it was $6.7 million, I believe.
And the jury decides that, or the judge?
The jury decides that, correct. Okay. And the 130 is essentially going to be an amount intended to punish the company for the conduct that they have engaged in. Now, that can't be covered by insurance.
Wow.
That cannot be covered by insurance. So let's talk about the amounts. And there's a special interplay here that's different than a normal, let's say, $2, $3, $5 million case. Okay? Because if you have a good attorney, which I know Bernard is a great attorney, they'll send something known as a 998 offer. Okay? And a 998 offer, and they have a counterpart in federal courts. It's a Rule 74 offer, which essentially says, this is what we believe the damages are at this time. If you don't pay it, there's going to be consequences to you not paying it. You have 30 days from this day to pay it. If they don't pay it, you're going to get 10% interest on that money that you get at trial all the way until the very end. Okay? So let's talk about the money they got. It's $137 million.
Oh, wow.
I'm sure that there was one of those offers made pretty early on in the litigation, and the defense attorney, the insurance provider, and or the company made a conscious decision to disregard that and to continue in the case. Okay? So they're going to get 10, think about it. It's 4 years, right?
Yeah, no, like
$137 million
That's a lot.
times 10% times 4 years
It's a lot.
is $40 million plus in interest.
A lot.
They should have paid. But let's say it gets reduced. Let's say it gets reduced to $75 million because they say that the punitive damages award is too high a multiple of
and
what
they would appeal that.
They're going to appeal it for sure. But let's say that it gets reduced to an amount that's within 1 to 9 times the amount. Let's just say roughly $75 million. You're still going to get interest on that $75 million.
Yeah, that's
an appeal will take a year to 2 years. So now we're talking 6 years, and at that point, there's probably an offer that was made 5 years ago. At $75 million, you're talking about 10% interest over that 5 years. That's $75 million.
You're still well over $100 million.
Over $100 million still. So the problem is, in the beginning, these types of offers were intended to force both sides to look at their case critically. To look critically. But I see way too many times game playing being had there, and they don't care what the 998 is. They're going to continue pressing on. And in this case, as intended from the legislature, it's to disincentivize people continuing litigation when they should have just paid. And in this case, they should have paid.
That's insane. So, okay, you're
go ahead, let them take 5 years to appeal it.
You're literally
you're not going to get that. There's so much interest. It's like go ahead. As long as we still get a massive amount of money.
Please keep delaying it, actually. The interest will just rack up.
Right.
That's crazy.
Okay, and then if you win, I still win.
Exactly. And even if you appeal, I still win. So, right. Okay. Tesla's rep, so she's like an HR executive, Valerie Capers Workman. She was quoted as saying, "While we strongly believe these facts don't justify the verdict reached by the jury in San Francisco, we do recognize that 2015 and 2016, we were not perfect. We're still not perfect, but we have come a long way from 5 years ago."
That's a PR. That's a PR.
Oh, 100%. You can hear it, right?
Yeah.
It's dripping in PR. It's dripping in self-preservation and saving face. But I'm curious to know, over the past 5 years, because I think a lot of people saw last summer as a turning point, and yet it's been probably about a 15-year almost turning point, if we think about it. Honestly, longer than that, right? Last year was the 30th anniversary of Rodney King. This coming year, excuse me, of the riots. I was born on that day. I can't believe I just got my full birthday wrong. Okay. But are we moving towards a brighter future? Are we, because yes, a bunch of these cases are going to stop popping up now, as you said. But I'm curious to know, like, what have been the mile markers on the way? Like, what are important historical cases that make it so that this case is possible? And also, what kind of legacy do you think this case will have in your field specifically?
So I have to basically make a comparison. So sexual harassment claims used to be really prevalent.
Yeah.
Okay. They would be really prevalent. And then a lot of sexual harassment and sexual assault cases came out, and there was some big verdicts. There are far fewer of them today. This case is going to stand basically as the flagpole that says that the community is rebuking this type of treatment, that it doesn't matter whether you're black, brown, green, orange, whatever it is, you should not be treated differently. And, I think that over the next couple of years, we're going to see a lot more of them. And over time, as a result of it being highlighted in the community, they will be lessened.
So
and that, I think, is
for you about the lessening, though, really quick, sorry to interrupt you. My question for you about the lessening, because I want to go back to sexual harassment. Do you think that means it's happening less, or do you think companies are getting better and litigation is getting better at convincing people not to pursue these cases?
Yeah, I think that, as it becomes more prevalent, people are going to be more aware of it. HR departments are going to be more aware of it. And as it happens, it's going to be stopped, it's going to be prevented, and there's going to be systems in place to prevent it from happening. I have a case, and believe it or not, in 2019, 2020, within a PowerPoint, and my client was an African-American HR representative. She was told, who was also doing recruiting, she was told to put in a PowerPoint that they only wanted white Caucasian males 26 to 40 years old. It still happens. So as it becomes highlighted, as these companies start, these cases start to become more public, that is going to have a negative effect on that type of conduct. So I think it's good. We're going to see it more over the next couple of years. Hopefully, my case you'll see in the news after next November. But I think that it's good for us as a community to recognize the harm and to make a stand against it.
Yeah, I mean, I think the visibility is extraordinarily important. I think it's also, again, hopefully will serve as a warning shot to corporations who do have sort of dark and stormy histories in terms of racial allegations, in terms of workplace abuse, in terms of sexual harassment and assault. Like, a lot of people are at their wits' end in terms of in life right now, right? We've spent the past year and a half in the most uncharted waters in, I would say, at least 20 years. And I think this is such a good, this is such a good catalyst for people who are at the end of their rope. And I say this to anybody who's watching, if you are experiencing workplace abuse, if you are experiencing a hostile environment, if you are being assaulted or harassed, or you've been injured at your job, you have rights. And there are people who will help you and who will work with you. I mean, I'm not saying you'll all make $137 million, but at least your voice will be heard. And at least, again, the more, as Jonathan has just said, the more we see these cases begin to pop up, hopefully workplace culture will begin to change. Listen, I'm so grateful that you took the time to join me this morning, and thank you for letting me ask you all of my golden retriever questions. I'm really looking forward to see what happens, especially if there's an appeal. And is there anything you want to leave us with? Any piece of guidance for those of us in the workforce? I
think that's it. After I get a verdict in my case, I'll come back on and I'll tell you about it.
Please, I can't wait. I'm going to look for your name in the news, and then I'm going to be like, Jonathan, it's time. Time for us to talk again. But yeah, I think you'll be my my resident workplace abuse litigation expert.
Happy to do it, Sydney.
Anytime there's news, you're getting a call. Thank you so much for spending your Saturday with us. Erupt. I will be doing some news stories for Instagram today, and then tomorrow, Mom and I are on at 1. I do a weekly segment with my dear mother. And this week we're talking about hope and the concept of hope and the radical concept of hope. So please tune in. Corinne also has a lot of great stuff going on. She did an Instagram takeover yesterday, so please check that out. And we're here all weekend. Jonathan LaCour, thank you.
Thank you so much.
Have a beautiful rest of your weekend, y'all.